Welcome everyone to our webinar today on tenants' rights and public benefits. Our presenters today are from the Georgia Legal Services Program, which provides hold on, let's restart this. Here we go. Welcome everyone to our webinar today on tenants' rights and public benefits. Our presenters today are from Georgia Legal Services Program, which provides civil legal services to low-income communities. Like all of us, they have worked to pivot their operations and services to respond to the coronavirus. So we are thankful to their team for taking the time to share their expertise with all of us today. I'm going to turn it over to Rick Ruffalo, who's the Executive Director for GLSP. Welcome, Rick.
Thanks, Emily. Appreciate the introduction, and welcome to all who have joined this morning. And a special shout out to all my Georgia Legal Services colleagues. I see you all logging in the chat box. Great to have you all with us today. It means a lot that everybody has joined us for this very important and informative webinar. As Emily said, I'm Rick Ruffalo. I'm the Executive Director of Georgia Legal Services Program. And at Georgia Legal Services, we meet the civil legal needs of Georgians with low incomes by providing them access to justice and opportunities out of poverty. We serve our clients in 154 out of the 159 counties throughout Georgia. We have 150 employees throughout the state who work out of 11 offices, although today we're working out of 150 offices as we are working remotely throughout the state. We've got 75 lawyers and other legal professionals who support our clients. As you will hear today, our legal professionals are doing some great work. We're representing clients, who face eviction and, are looking to keep a roof over their head. We're helping families secure public benefits so that they can put food on their tables. And we're assisting wage earners in maintaining their income that's been severely jeopardized by this global pandemic. And so our goal today is to give you practical advice. Whether you are serving similar clients to those clients that Georgia Legal Services represents, or it may be that you're in need of advice and counsel and practical information yourself. And so you're going to hear from some great members of our team, and I want to take a few minutes to introduce each of our panel members. First is Kaleem Barkley, who's an attorney in our Augusta office and a member of our eviction prevention project. In his role, Kaleem provides legal advice and counsel to tenants in privately owned rental housing. Welcome, Kaleem. Fran Montalero is our benefits hotline supervising paralegal, and Fran, in her role, helps clients get the food and health care they need, which would otherwise be delayed or denied without Fran's expertise. Welcome, Fran. Also joining us is Cynthia Gibson, who is the managing attorney in our Dalton office, which serves clients in 6 Northwest Georgia counties. In addition to her leadership role, Cynthia serves as our health law specialist and ensures that state and federal agencies are held accountable to provide necessary healthcare benefits to our clients. Welcome, Cynthia. And finally, Celinda Hansford, our managing attorney in our Piedmont office. Celinda and her team represent clients in 15 counties outside the metro Atlanta counties. And Celinda brings a wealth of experience to Georgia Legal Services. Served as a public defender, a magistrate judge, and has also managed her own law firm. So welcome, Celinda. So those are the panelists that you'll hear from today, and let's jump right into it. We've seen so much about pending evictions, and if you read the news, you'll hear a lot about what people are predicting to be a tsunami of evictions. There have been some court orders that have stayed evictions for a period of time, but those orders will soon be ending, and we fully expect to see a significant increase in the number of dispossessory hearings filed. And so to give us an update on evictions and other issues facing tenants, let me turn it over to Colleen Barkley. Colleen.
Thank you for the introduction, Rick. And thank you for Emily for hosting us today. Again, my name is Colleen Barclay. I'm with Georgia Legal Services Program. I'm a staff attorney who is also an eviction prevention attorney with Georgia Legal Services Program. Now, today we're going to do a brief overview of tenants' rights in Georgia. We can go to the next slide. So tenancies in Georgia fall under two categories. You have your written leases and you have your tenancies at will. Generally, under written leases, you have a feature of specific rules, guidelines, and the length of the tenancy. Everything is spelled out in the written lease agreements, when to pay, who to pay to, how to pay, what rules you need to abide by as a tenant, and what rules the landlord needs to abide by as your landlord. Everything is essentially spelled out in those types of tenancies. Now, you also have something called a tenancy at will. Those are generally called month-to-month tenancies, and they feature no written lease generally. And they have some different rules that apply to them. In a month-to-month tenancy, an individual will be subject to changes of rules made by their landlord with a 60-day notice. So the landlord can increase rent with a 60-day notice, can let tenants know that the rules are going to change with a 60-day notice, and can terminate the tenancy with a 60-day notice. These types of tenancies usually persist on a month-to-month basis and are usually picked by individuals who are in situations where they can't necessarily commit to a year-long type lease agreement. I often encourage people to consider written lease agreements as they have an advantageous effect of locking in rules so that you know what you're responsible for, how things will operate in your tenancy, and generally what will happen in your tenancy without any surprises from the landlord given a 60-day notice. Now, on the plus side, if you are in a tenancy at will as a tenant, you do have the ability to terminate your own tenancy with a 30-day notice. This gives tenants a little bit more flexibility if they're moving from place to place or know they're not going to be in one area for too long. Okay, next slide. So getting into the eviction process, landlords must provide tenants with a demand for possession prior to filing an eviction. Demand can be as simple as stating that you've missed rent payment and rent needs to be paid or you need to move. Demand can also be the intent of the landlord to lease the property to another individual after a tenancy is over and done with. And demand can also be as simple as stating, I would not like to continue this lease agreement after the lease agreement has, of course, run its course. The 60-day notice requirement in a tenancy at will is not equivalent to demand. So after that 60-day notice is up, let's say the landlord wants to terminate that tenancy, provides a 60-day notice. The landlord also has to provide a demand for possession of the property as well. After that, the landlord must go to the magistrate court or civil court or municipal court in their area, whichever holds jurisdiction over dispossessory hearings, and file a dispossessory affidavit with the clerk of court. This will begin the official dispossessory or eviction process. Now, the affidavit will state the grounds for the eviction and how much, if any, is owed to the landlord by the tenant for the tenant's failure to pay rent or any damages that the landlord has incurred from the tenancy or any rules that have been broken. The affidavit will spell all of that out, and that will be grounds for the eviction. Next slide. Service. So after the landlord files for the dispossessory affidavit, of course, the tenant has to be served on the dispossessory warrant. Now, there are two types of service that are important to consider, both personal service and tack and mail service. In personal service, the marshal's office or the sheriff will serve the tenant personally in hand. So you can expect an officer to come to the tenant's door, knock on the door, find the tenant present, and they will serve the tenant with the dispossessory warrant in hand. The tenant is then to file an answer to personal service types of service. This has the feature of protecting the tenant and providing a court date to the tenant so that you don't have a judgment for money if you don't file an answer. This kind of differentiates from tack and mail service, wherein a tenant cannot be found by the marshal's office or sheriff's office. So the officer serving the papers will tack the dispossessory summons to the door and mail it to their last known address of the tenant. Now, this has a feature of stating that if the tenant cannot be found, then the tack and mail service provides this avenue for not filing an answer. So if you don't file an answer to a tack and mail service, you have the ability to get that default judgment. Of course, the landlord can get the default judgment, and the default judgment will give the landlord an immediate writ of possession, but differentiating it from personal service, the tack and mail service will protect the tenant from a money judgment. The landlord cannot collect a money judgment in a tack and mail service where the tenant does not answer. However, in personal service, if the tenant does not file an answer, then the landlord can collect a money judgment. So the positives of the tack and mail service is a tenant is unable to pay and they know that they're unable to pay and they have somewhere to move relatively soon. It may be the best strategic move to not file an answer in a tack and mail type service. But in personal service situations, I always encourage people to file an answer in a dispute in court so that they have a court date, so that their time is extended and that they have some arguments that can either assist them in court or provide them more time to move from the property. Next slide. So there's some rules with filing an answer. So an answer must deny, dispute, or challenge the claims that the landlord has alleged in the dispossessory affidavit. A tenant has 7 days from the service to file an answer with the court. The information on where to file will be located on the dispossessory affidavit and summons that the tenant receives. It's always important that when you file your answer and you deny, dispute, or challenge the landlord, that you provide some substantive information or at least state that the information in the dispossessory affidavit is not correct and you dispute it, and this will provide you with a court date. If you do not deny, dispute, or challenge the landlord's claims, you will likely face a situation where your answer is struck and it will count as a non-answer and a response. This will result in the landlord being provided a default judgment as soon as the 8th day and a writ of possession that could come for the landlord and immediate takeover of the property and possession of the property again. Next slide. So generally, tenants in current COVID times will need to contact the court prior to filing an answer to determine if the court is open and what safety procedures are in place. A tenant should file an answer within 7 days of receiving the dispossessory affidavit, or a default judgment will be implemented by the court and the landlord will be provided with an immediate writ of possession. A tenant nowadays should contact the court to determine the appropriate manner in which they're going to file their answer. As a note of practice, it is always and has always been the practice that a tenant files the answer in person. Things may change with court closures and the pandemic response from courts, but generally tenants are to file their answers in person within 7 days of receiving the dispossessory affidavit, whether personal service or tack and mail service. It only changes if your court has a different procedure that they're following for the safety of the courthouse and their officials. I encourage tenants to call in to make sure that they are to answer in person and to ask about any procedures to the contrary. But as a rule of thumb, always file an answer in person. Next slide. So there are certain defenses that a tenant may utilize to protect them against the dispossessory affidavit that will act as a complete defense. The main one and the bread and butter of the defense that a tenant may have for non-payment is called the tender defense. Now, Georgia Code 44752 provides the tender defense to tenants who are served with a dispossessory affidavit for non-payment of rent. So if a tenant pays all rents allegedly due in the dispossessory affidavit, plus the late fees and the cost that the landlord paid for the dispossessory affidavit within 7 days of service, then the tenant has a complete defense to the dispossessory affidavit. This is a complete defense. Now, you can either pay the landlord that money or pay the court that money. I encourage my clients to always pay into the court registry within that 7 days of service. So they need to pay the rent, the late fees, and the cost of the dispossessory warrant. The court will have the amount that the dispossessory warrant called for, so it's always incumbent upon the tenant to call the court so that they understand how much it costs to take out that dispossessory warrant so that they submit the right amount of money into the court registry. This defense may only be utilized once in a 12-month period. So you have one shot per year to use this type of defense, and it is a helpful defense because it is a complete defense. This money is necessary and needed within that 7-day time period following service. The timing is strict, important, and most importantly, paramount. It is of the utmost importance that tenant have these funds in the 7-day time period of filing an answer. So any organizations that are providing money or rental assistance to tenants, this money needs to come in that 7-day time period that they receive an answer. So I encourage my clients, if they anticipate having an issue paying rent, to reach out to these organizations that provide rental assistance beforehand, maybe when they receive a demand for possession, or maybe even before that, in the middle of the month prior to the next month, where they are likely to receive a non-payment of rent dispossessory affidavit. Because the timing is strict on this. Otherwise, payment is outside of the law and is going to be subject to the discretion, the biases, and the mood of either the court or the landlord. And we don't want a situation where we're trying to appeal to the better angels of landlords or judges. We want to stay within the law, and we want to provide the most optimal defense within the time period prescribed by the law. Next slide. So recently, Georgia has provided a retaliation protection for tenants. So tenants are protected when they request repairs or exercise their rights under Georgia law regarding repair issues. A landlord is presumed to have involved themselves in a retaliatory action if he attempts to terminate a tenancy or evict a tenant within 3-month period following a repair request, not related to non-payment of rent. If the tenant contacts a government agency about repair issues, makes a complaint to the landlord about repair issues, or participated in any type of tenant organization regarding the condition of the property, and the landlord takes an action to either provide a 60-day notice to that tenant shortly after or within that 3-month time period of that tenant making those claims and issues, or they file a dispossessory affidavit for something that's non-payment of rent related, then it is presumed that the landlord has engaged in a retaliatory action. A tenant should always make this clear in their answer and provide this defense. Now, the landlord will have to rebut these claims in court, but it is presumed that the landlord has taken this retaliation type action, and they're going to have to provide some evidence that they did not. If the landlord was shown to have been retaliating, then this defense also entitles the tenant to some damages, which will be very good for the tenant. Next slide. So hearings. If a tenant files an answer, a hearing, of course, is going to be scheduled by the court relatively quickly. In the COVID era, it may be a little bit backed up, but tenants can't rely on hearings being too far out. They should always prepare for a hearing within 1 to 2 weeks of filing their answer. If the time period for a hearing is extended, tenants need to know that they need to pay their amount of rent in a timely manner into the court registry. So if they are required to pay between the 1st and the 5th of the month, tenants should pay between the 1st and the 5th of the month into the court registry under their civil action number. The court hearing is usually informal and goes very quickly. A lot of tenants expect a long, drawn-out trial, but dispossessor hearings are relatively quick. Some can be as short as 2 to 3 minutes. They rarely go over 15 minutes. Tenants need to prepare for that and understand that that's the process of the magistrate court dispossessor hearing. If the court rules in the favor of a landlord, is going to issue a writ of possession following the judgment. So it's usually going to be 7 days after the hearing or when the judgment is entered. Next slide. A tenant also has the ability to appeal. So if a tenant feels as if they have the ability to pay and that the court didn't properly hear their issue, then they have the right to appeal a judgment after trial. So an appeal may be entered at the clerk's office within 7 days of the judgment. If the tenant appeals and desires to keep possession of the property, the tenant must pay the amount into court found due into court, plus the court costs for filing the appeal, which may be waived by a pauper's affidavit. Payment of past due rent is non-waivable. So if the tenant has a strong belief or basis that their dispossessory hearing resulted in an improper ruling, then they are encouraged to appeal and they have the right to appeal under law. That appeal just has to be done within 7 days of the judgment date. Next slide. So during the COVID-19 era, the Congress passed what is known as the CARES Act. And now this provided a protection for eviction for non-payment of rent. And this protection kind of expired July 25th. This protection was from March 27th to July 25th of 2020. And it protected tenants in covered properties and provided an out for them not being able to pay their rent. Now, rent still accrued during that time period, which tenants need to be very aware of. However, late fees are not applicable to any amount that accrued during that time period. The CARES Act coverage covers properties where an individual has to do an annual income recertification, where a tenant deals with a public housing authority, or if their rent adjusts based upon their income. That's a 3-step hard rule of whether or not your property is likely covered by the CARES Act. Tenants are usually not covered by the CARES Act if the landlord filed prior to March 27th, 2020, and the landlord filed claiming that the tenant broke a rule of the rental agreement other than non-payment of rent. And we must consider Magistrate Court Rule number 46 as well, where landlords must file an affidavit that they are not a covered property under the CARES Act. The court is attempting to make sure that everyone is aware whether or not a property is covered by the CARES Act or not, so that the proper procedures can take place. Even after July 25th, a covered property must provide a tenant with a 30-day notice before it files an action with the court. So that rule still applies. So if a tenant is living in a covered property and the landlord is thinking about filing a dispossessory affidavit, then the landlord has an additional federal requirement that they are to provide a 30-day notice before it files a dispossessory with the court. Next slide. So covering properties covered by the CARES Act, as I provided those 3 rules that people should always consider. If the rent adjusts based upon income, if the tenant has to do an annual income recertification, or if the tenant deals with a public housing authority, you're likely under the CARES Act and you likely live under a covered property. But being more specific, we're looking at government subsidized housing, public housing, housing vouchers, low-income house tax and credit properties, and other types of properties covered by VA loans, Freddie Fannie loans, and USDA loans. CARES Act only applies to non-payment of rent evictions. That's what people need to keep in mind. People also need to keep in mind that the rent that was accruing during this time period while not payable during that time period, has accrued and will become payable after the CARES Act protection ends. That's an important thing that people need to keep in mind, and any organizations that are participating in rental assistance needs to keep in mind. Some individuals have run into a situation where they've been unable to pay this entire time, and they may have this huge debt incoming. So it's something we all need to consider as tenants reach out and request funds, because this may be a significant amount for a good amount of people in Georgia. Next slide. So if you have any contact with any tenants that reach out to any of your organizations for rental assistance, but they also need some guidance on their rights under Georgia law, they may contact Georgia Legal Services Program, whether or not they're in public housing or whether or not they're in private housing. And we will do an assessment and we will do intake on them, and we will attempt to provide them with as much information as possible and possible legal advice and counsel with their issues. They can always call 1-833-GLSP-LAW or 1-833-457-7529 for assistance. And that is the presentation on tenants' rights. And thank you for hosting GLSP.
Thanks, Kaleem. Really appreciate that that overview. Very helpful. I hope those of you attending the webinar, if you have any questions or additional information, please feel free to call our hotline, 1-833-GLSP-LAW. I know there's been a couple of questions in the chat box, so I think those are being answered there. Let me just address one question, general question about the slides. We will find a way to either post them to Georgia Center for Nonprofits website as part of the recording. We can also post them to the Georgia Legal Services Program website so that people have an opportunity to view those after the webinar. Okay, so it's a great overview of what Georgians are dealing with in housing. Equally challenging are the issues our fellow Georgians are dealing with in accessing public benefits. On the one hand, there's been a significant amount of funding available, but that always comes with myriad challenges of trying to navigate these very onerous state agency websites, difficulty in getting through on phone calls, and so we've got panelists who are going to talk about public benefits and some practical advice on how to access those public benefits. So up first, Fran, would you like to kick us off on public benefits?
Yes, thanks, Rick. I'm Francesca Montalaro with the Georgia Legal Services Benefits Hotline Program. And I'm going to explain SNAP benefits, which is food stamps, and the PEBT SNAP benefits. This screen references the benefits hotline toll-free number to call. If you are a Medicare recipient, then you can certainly contact the benefits hotline for help. And also we've posted our Georgia Legal Services phone number, which Kaleem just shared as well. Next screen, please. How to apply for SNAP, Medicaid, and TANF. Those essentially are public benefits. You can go to the DFACS website, which is called Gateway, to submit an electronic application. And since all of the DFACS offices are currently closed due to the pandemic, an electronic application is really your best option. However, you can certainly contact the benefits hotline. We are equipped to submit or help you get a paper application form if needed to turn in a written application. Next screen, please. This page here is what the Georgia Gateway website looks like. This is their homepage. It often will reflect updated information regarding public benefits for PSNAP, which is the Pandemic SNAP program, food stamps, extended deadlines for public benefits like Medicaid and food stamp reviews have been extended. Typically, this page will show you any updated information in regards to public benefits and also lead you to the screen that helps you submit an electronic application. Next screen, please. When you're on the Georgia Gateway homepage, in the bottom right corner of the screen, it will show you how to create an account. And just like with any website, you need to select your user ID and your password. I always recommend having a pen and paper handy so that you can note the user ID and the password you create and write it on something that you will not lose, or save it when you create the account, save it on your computer. This screen lets you apply for benefits, access your benefits, as well as manage your account. Next screen, please. And this screen here is what you see once you have created your account. The Gateway website will let you choose to apply for benefits. If you are a new applicant, that would be your first stop, is to apply for benefits. If you already receive TANA, food stamps, Medicaid, any of the public benefits, and you already have a case with defects, then you would choose the first blue box. If you have never enrolled in any programs, then you would go straight to the Apply for Benefits tab. Next screen, please. And this screen here is the benefit summary page where you can see what options you have. If you want to view notices, letters that DFACS has mailed you, you can see below there is a button that says My Notices to look at your notices. You can also, if you look at the very top of this screen, you can submit changes. For example, if there's a household size change, an income change, you can make your changes here. If someone has moved out, you can also make changes here. Upload documents. Sometimes DFACS wants you to provide a copy of your ID card, medical bills, and also the Apply for Benefits tab. So this screen gives you multiple options in which to use the system. The dark navy blue bar shows submitted applications, renewals, and changes. So if you're wondering about the status of an application that I've turned in, you can click that blue bar and it will show you the date you turned in your form, if it's been registered as received, if it's pending, in progress, or completed. So all of these tabs here are useful regarding managing the Gateway website. Next screen, please. Food stamp basics. The SNAP, which stands for Supplemental Nutrition Assistance Program, food stamps, the EBT, Electronic Benefits Card, which is literally a card that they put the EBT benefits on, like using a debit card. You create a PIN number, you can call and check your transactions, card balance, and also if the card is lost, that phone number on the back of this EBT card will let you reorder a card. How clients get their benefits. These are all the food stamp basics we're going to go over. Next screen, please. Food stamp eligibility. Income limits with public benefits are always one of the first things that DFACS uses to make a decision. Each program has an income limit based on your household size. Income limits change every October 1st. To get updated information, you can check the FNS website. There is a gross income test versus a net income test. Typically, if you're a senior citizen, meaning anyone in the home that is 60 years old or above, does not have to qualify for the net income test. They also considered your household with disabled persons. Elderly, again, would be considered 60 and above. Typically do not have to meet the gross income test. All households must meet the net income test to be eligible. Next screen, please. This screen will show you the income limits based on your household size, and these are usually effective through September of the last day of this year. Every year in September, they update these income limits because of the cost of living. It shows you on the far left, if your household size is 1, 2, 3, and so on, what the gross income limit would be, and then what the net income limit would be. So if you are not a senior, they are certainly considering your net monthly income. And this is how you can discern for yourself whether or not you would even qualify for the minimum amount in food stamp benefits. Next screen, please. This screen is also helpful because it lets you know if you have a household size from 1 to 8 people, what the maximum benefit amount will be. Over the last 3 or 4 months, DFACS has issued benefit maxes to people who are receiving food stamps as some relief during the pandemic. And the last issuance of maximum benefits was distributed on July 1st. We have not yet heard if they are going to continue to do that as the pandemic continues. Next screen, please. The Georgia Benefits Hotline is set up to assist people who are on Medicare, whether you're elderly or a disabled person. We assist with applying for Medicaid, the Medicare Savings Program. We assist with applying for SNAP and Senior SNAP, food stamp benefits. We also assist you with getting the proper information to complete a low energy income assistance application for LIHEAP, which helps you with your utility bills. And we assist with referrals for our kinship care program, which are grandparents raising grandchildren, as well as the elder abuse and the DV hotline. Next screen, please. How can families get PEBT? And when we were going over our notes this morning before the call started, it was brought to my attention because this is typical how the things change on a daily basis or overnight. There is actually a link on the home page of Gateway. If you look in the middle of the screen, it will tell you how to apply for PEBT benefits, especially if you're a household who originally was not getting food stamp benefits at all. If you're a household that has children and you're already receiving food stamp benefits and you have your children listed on the application as a household member, there would not be anything additional you need to do. However, if you do not currently receive SNAP benefits, you would certainly go to the Gateway website and look to the middle of the screen to see the application bar that will direct you to the next page to apply for PEBT benefits. These benefits are allowed for households who have children that were receiving free and or reduced lunch program. You will need to fill out an application to get the $256.50 additional funds put on your food stamp card, and that amount is per child. And the application recently became available this month, and I believe there is a September deadline. So make sure when you go on the Gateway homepage, if you're new and you want to get these benefits and your children were getting free or reduced lunch, the middle of the screen on that website will reference where you go to get the PEBT application turned in. Next screen, please. And this basically reiterates the prior page. The benefit amount, $256.50 per child, would be the maximum benefit allowed for pandemic food stamp benefits. Next screen, please. And our Georgia Legal Services Program hotlines, again, the benefits hotline for people that are receiving Medicare benefits would call the first number. We have the Georgia Legal Services Program Kinship Care hotline. You can make note of this phone number as well, and kinship care is typically reserved for grandparents raising grandchildren. And we also have our Georgia Legal Services Program Domestic Violence and Advice hotline, which you can reference as well. Next screen, please.
It says mute my auto.
Okay, well, that's it. So the next presenter is up, and thank you for your time. Y'all be well.
Hi, if you're not presenting, if you would be sure to mute your phone, please. Thank you. Fran, thanks very much. Really helpful advice to be able to walk us through some of those challenging issues, and particularly some of the websites and where to find the information. As we move into the presentation, so we spent time talking about how to secure public benefits, specifically around putting food on the table. Now let's turn to healthcare needs, and walking us through the next part of the presentation is Cynthia Gibson. Cynthia, tell us about Medicaid.
Hi, thanks, Rick. Yes, my name is Cynthia Gibson, as Rick said, and Medicaid is the most important health insurance for our clients. As you can see, this year, Medicaid covers almost 2 million people. So that's a lot of people. However, the vast majority of those covered by Medicaid in Georgia are children and those who have Medicare coverage. I've also got our number on here, and one thing also is if you go to our website, which is glsp.org, we do have an online application where people can fill in some basic information online, which goes to our intake paralegals who will return their calls and see if they have an issue that we can help them with. All right, next, please. One of the first things for people who aren't really familiar with Medicaid is to determine what it is that the caller actually gets and what they're needing. Many people don't understand the difference between Medicaid and Medicare because the names are so close. But Medicare is the insurance that people get when they turn 65 or if they've been on disability for 2 years. Medicare you pay for, you pay a monthly premium, you see it taken out of your paycheck on taxes, your Medicare taxes when you're working, and that's everybody is eligible for that. There's no income limit, you just have to sign up, you pay your premiums, and you're eligible. One quick and easy way to find out if the person you're talking to has Medicare or Medicaid is to ask what color their card is, because the Medicare cards are red, white, and blue at the top, and so that's an easy way to identify that. On the other hand, Medicaid is the program that covers people who have limited income. Generally, they're going to be over 65, meet disability standards, or be children under 19. This here just tells you some of the major categories, such as pregnant women can get Medicaid, parents or caretakers who have minor children, women with a diagnosis of breast or cervical cancer, and women between ages of 18 and 44, but that's only for family planning purposes. And the income limits for each of these categories is going to vary. There's not one income limit for everyone, unfortunately. Next. So let's say you're really fascinated about Medicaid and you really want to dig into this and learn about it. So the easiest way to get more information is to go to the rules that the state uses when determining eligibility. And that is what we call OTIS. And the website is here. You select the Division of Family and Children Services and then the Medicaid manual. And that is going to give you all of the rules broken down in each category. It'll give you all the different classes of assistance, what the requirements are, and the income limits. Everything you could want to know is going to be on those in those manuals. There are other specialized Medicaid programs that are waiver programs. So under the general Medicaid, if you qualify, you get coverage. That's it. There's no limit. Under the waiver programs, if you qualify and there's space and funding available, you get coverage. So there will be people that will qualify for some types of Medicaid, but there's waiting lists, so they may not get coverage right away. Now, the thing to note is these manuals are not the final set. These are the state's interpretation of the federal Medicaid regulations, so they can be challenged if they violate what the federal regulations say. Next slide. So as Fran said, to apply, you have to go to Gateway right now. That's really the only way or the best way to apply is online. Of course, not all of our clients have internet access, and not all of them are really computer savvy and know how to use the internet. So I've often done this online for my clients when they weren't able to do so. Just have them on a call and ask them the questions and fill it out for them as if I was them. You can also print out a paper application, which you can find online. You can send it to them and they can fill it out. Now, they can mail it to the local DFACS office, I don't recommend it because I never really trust that the mail will not get lost. So it'd be better if you could fax it for them or email it into the local DFACS office, so there's some tracking and accountability where you can prove that an application was submitted. Once the pandemic is over and the offices reopen, of course you can apply at the local offices. In some health departments, you can apply through there, and that's often a bit easier for people. And some hospitals also have staff that can help you apply. Now, the application is really long if you do the paper application, and it will take at least 30 minutes to do an application on Gateway. For clients who are currently getting benefits, who've had reviews due in the last 6 months since this pandemic started, their benefits have been automatically extended, so they don't need to worry about it. And that is true through October of this year so far. Next. So what do you need to be eligible for Medicaid? Well, first, there's income limits. They're going to vary depending on each type of Medicaid. There's resources. Now, if you're dealing with children and family Medicaid, there's no resource test. But if you're dealing with age, blind, or disabled, there is. You have to be a resident of the state of Georgia, and you have to be lawfully present in the U.S. There is an exception for some people who are not lawfully present. It's for under emergency Medicaid, but that only covers if you have a medical emergency and you go to the ER and you need treatment to save your life, and the hospitals apply for that Medicaid. So that's not something you can say, well, the doctors told me that I need surgery and I really need to have this done, so I'm going to apply for Medicaid and get emergency Medicaid. It doesn't work that way. For people from other countries who are documented and have been here for 5 years, they can apply for Medicaid, but there is a 5-year waiting period generally. There was a new public charge rule that many people have heard about. Medicaid is not going to result in your client being considered a public charge. And that's really important because a lot of citizen children are eligible for Medicaid, but their parents may be afraid to apply, afraid that it might impact their immigration in the future. And as the law stands now, it does not. Next. So the income limits vary based on household size and the different groups. There's certain types of income that doesn't count. Whose income counts? It varies depending on who's in the household. You may have a mother and 2 children with her husband, with the father of the children, but they're not married. They're both adults' income is going to count. Well, what if you have a mother and 2 children and her partner's in the household, they're not married and he's not the father? Well, then his income doesn't count. I just give you that as an example of how it changes depending on the specifics of each case. There are resource limits for the age, blind, and disabled Medicaid, but many resources don't count. Like the home you live in, they're not going to count the value of that. One car doesn't count. Of course, if both adults have a car, then they are going to count one of them. There is no resource in family Medicaid. There's no resource limit for that. But we often see errors in calculating the resources and the income. So it's important to check and make sure that's done correctly. This just tells you the major groups of elderly or disabled people who would be eligible for Medicaid in Georgia. The resource limit is $2,000 for an individual, $3,000 for a couple, and that's very low. Next slide. So Medicare is the Part A, the Part B, the Part D, and sometimes Part C. That's the part that everyone gets when you turn 65, you sign up for it. But you do have to decide what's best for you. And we recommend Georgia Cares as an agency to help seniors choose what is best for them as far as, do they want a Part C? Which Part D plan is going to work for them? Next. This is the Medicaid for people with Medicare. This is one of a really important type of Medicaid for our clients in that it pays the part, your Medicare cost. Medicare is not free. Part B premium is $144.60 a month. There's deductibles, there's hospital deductibles, there's co-pays and co-insurance amounts. But if you are low income, then the state might pay those costs for you. And this chart tells you the income limits for 2020. Now, these income limits will be in place until March or April of next year until they update them again. There is a resource limit, but it's higher than the general Medicaid resource limit. So if you deal with any seniors, always screen them for these programs because there's too many seniors out there that could get this help and aren't aware of it and are not getting it. Next. So this shows you who can get Medicaid. And as I told you, the vast majority are children because that's the highest income limit. It's for children to get Medicaid. Next is pregnant women. This year, Georgia did make a change to allow pregnant women to keep their Medicaid for 6 months after the baby is born. It used to be 60 days. Women who have breast or cervical cancer, those who are in a nursing home, those who are over age 65 and have SSI. The group here, the adults without minor children, they're not eligible for Medicaid in Georgia. That's where, if Georgia expanded Medicaid, that would help that group of people. And parents of minor children are eligible, but you'll see the income limit is only 38% of the federal poverty level. So that is incredibly low. Next. This is the major groups of families that are eligible. One thing to note is for children, the eligibility level goes down as the children get older. So when you get up to ages 6 through 18, the household has to be 138% of federal poverty level or lower. But ages 1 to 5, it's 152%, and under age 1, it's even higher. Next. When you're including income Medicaid for children, this type of income in the household does not count. So child support does not count. Alimony, earned income tax refunds. There's different things that don't count. Next slide. So what if you have looked at all this and they're just not eligible, they're over income? Well, then the next step to get health insurance is the Affordable Care Act. And just remember that there are subsidies available for households that are lower than 400% of the federal poverty level. And those subsidies can reduce the monthly premium and can reduce the deductibles also. So make sure to help your clients explore that. And lastly, if you have a client you think they're eligible but DFACS has said they're not, that is not the end. Make sure that you submit what's called a fair hearing request. Help your client do that. Refer them to us. We can make sure they did it right. And if we find out, oh, well, yeah, they did do it right and you're not eligible, it's a very simple process to withdraw that hearing request. Not a big deal. People don't need to be afraid of it. Last slide. So, if you're completely confused and lost about Medicaid, it is complex in Georgia. There's so many different categories. My contact information's on here. Give me a call, shoot me an email. I'm happy to help you walk through it for a client. Thank you.
Thanks, Cynthia. Again, very informative in managing these very complex issues through state agencies. Cynthia is an expert, so please do take her up on her offer. Call her, email her. She's happy to help you navigate through these complex issues. So when we talk about public benefits, we've heard about how to secure benefits around putting food on the table and providing for health care. In our third area on unemployment benefits, again, as a result of the pandemic, we're seeing this staggering number of unemployment claims, just unprecedented. And through no fault of the wage earner, this pandemic has, just had this, terrible effect on so many families. And you think about, someone who's been able to provide for their family basic human needs, who has now lost her or his job, and just the ripple effect that it has in putting food on the table, making rent payments, being able to provide for members of the family. And so Celinda Hansford is going to give us an update on unemployment benefits and how to secure those. Celinda?
Thank you, Rick. I'm Celinda Hansford, and I'm going to talk to you today about unemployment benefits. I have a quote here that says, "Don't give up, it's worth the wait." And I'm going to talk a little bit more about what that means, because I really want people to recognize, regardless of what's going on with the ability to get benefits, that they shouldn't give up, that it's worth waiting for those benefits. Next slide. Under the CARES Act, it provides for several programs, and these programs are excellent for individuals who are seeking unemployment. And I've listed the programs that are provided under the CARES Act. Next slide. I'll talk about most of these programs. I'm going to start initially with the one that most people are familiar with, which is the state benefits. To be eligible for state unemployment benefits, you must have sufficient wages. So what does that mean? That means that you must have wages in at least 2 quarters of the base period. And so when we're talking about what is a quarter, we're talking about 3-month period of time. So January, February, March, April, May, June, and so forth. The base period is generally considered to be the first 4 quarters of the last completed 5 quarters before you file. So as a general example, if I were to file for unemployment benefits in, let's say, April or May, the first 4 quarters of the last 5 would generally be all of 2019 if I filed in 2020. So your wages in the 2 highest quarters of that base period must equal at least $1,134. The total amount for the wages for that entire base period must equal at least 1.5 times the wages of your highest quarter. So that is what we're talking about when we say sufficient wages. Aside from the fact that you need sufficient wages, you also need a job separation from your last employer, and that separation must be due to no fault of yours. You also must be able and available and actively searching for work, suitable work during the time period, and be able to provide proof of lawful presence in the U.S. Next slide. So I'm going to start by talking about one of the programs that the CARES Act provides for, and that is the Federal Pandemic Unemployment Compensation, which is an excellent program. And the reason why I say it's an excellent program is because it will provide $600 a week in addition to your regular unemployment benefits. So one of the things that must happen, though, of course, is that you must be eligible for state benefits in order to be able to get the pandemic unemployment compensation. It does end July 25th for employee file claims and July 31st for employer file claims. However, not to panic, if an individual has filed for unemployment benefits and they've been claiming or certifying those benefits weekly, that they'll get benefits retroactively. Next slide. The pandemic unemployment assistance is for individuals who are self-employed, gig workers, independent contractors, employees of churches and nonprofits, as well as individuals who have limited work history. So in order to be eligible for pandemic unemployment assistance, you must have been denied state benefits first. So what generally happens is when you get a denial for state benefits, you should also get an email that connects you to the application for pandemic unemployment assistance. So there should be a link. Next slide. The basis for pandemic unemployment assistance is that applicants will need to show that they are partially or fully unemployed and they are unable and unavailable to work due to certain conditions. And I have listed all of the conditions on here that an individual can assert if they're saying that they're seeking pandemic unemployment assistance. Some of these, they must have been diagnosed with COVID-19 or have symptoms of it and are seeking a diagnosis. A member of their household has been diagnosed with COVID-19, that they are providing care for a family member or member of their household that was diagnosed with COVID-19. Next slide. A child or other person in the household for which that individual has primary caregiving authority for is unable to attend school or another facility that is closed as a direct result of COVID-19, and such school or facility care is required for the individual to work. The individual is unable to get work because of a quarantine that was imposed by COVID-19. They are unable to work because they have been advised by a healthcare provider to self-quarantine due to COVID-19. They were scheduled to start employment and do not have a job or are unable to reach the job due to COVID-19. Next slide. And because of the death of the head of household that was due to COVID-19, they have now become the primary breadwinner or major support for the household, or they had to quit their job as a result of COVID-19. Their place of employment is closed as a result of COVID-19. And if the individual is unable to fit in any one of these categories, they may be able to meet some additional criteria that was established by the U.S. Department of Labor. Next slide. Pandemic emergency unemployment compensation is another program that is offered under the CARES Act. It is also an excellent program because it is an extension of your regular unemployment benefits. So what it does is it adds 13 weeks of benefits to the end of your regular unemployment benefits. Of course, you would have to be eligible for benefits, and this allows you to be able to collect unemployment benefits for a longer period of time. So an individual could potentially be eligible if they've been unemployed between March 29th and December 26th of 2020. The other part of the pandemic emergency unemployment compensation is that the individual must have exhausted their regular state or federal benefits and must be ineligible for state or federal benefits and is able and available to work. Next slide. So, as I'm sure many of you are aware, during this time period, and just as Rick has indicated, there have been a lot of claims for unemployment benefits in light of what's going on, and rightly so. And so with that comes a lot of challenges. Because of the influx comes a lot of issues. And so with the issues and challenges also comes a lot of frustration. And so what I would say to anyone who is trying to get unemployment benefits, apply for those benefits. And this is a great opportunity to do that. This is why I say don't give up, it's worth the wait, because under the CARES Act, unemployment payment amounts are increased, more workers are qualifying, and benefits are available for longer periods of time. So it's definitely worth the wait to go through what you need to in order to get the benefits that you're seeking. So I have some suggestions here on how to apply for unemployment benefits. first and foremost, I would say, try to use a computer if you can, understanding that some people don't have access to a computer and have to use their mobile phone. But a computer is better, it's easier to navigate through the process if you're using a computer. And that is because you have to apply online, and I have the Department of Labor's website on the screen where you can apply. When you go onto the Department of Labor's website to apply, you're going to create an account using your social and a 4-digit PIN number. My suggestion is that an individual checks that account on a regular basis. It gives them an idea of what's going on. Sometimes there are notices in that account that they may not have received in the mail, but it may be in their account. So it's a very good idea to check it on a regular basis. An individual also wants to make sure that they give their email address, that they ask questions via email address, check their emails regularly, and particularly check the junk and spam, because what we found is that a lot of responses may go into an individual's junk or spam mail, and they may be thinking they haven't gotten any type of response, but they have. Also check voicemails regularly. I wanted to talk about the benefits determination notice. So when an unemployment application is filed, it is very important that once you get the benefits determination notice, that you look at it, that you make sure that your wages are correct. That way, it can minimize the incorrect amount of weekly benefits that you receive. So that's very important that you check that document, because we've had individuals who get a benefit determination notice and just automatically assume that it's correct, and then when the payout starts coming, they get the incorrect benefit amount. So that's real important that you do that. Another suggestion or tip for you is when you've been denied state benefits, then you should apply for a pandemic unemployment assistance. So in order to do that, though, when you get the denial, as I stated earlier, they will send you a link for you to be able to apply. If you don't see the link, if you don't get an email regarding that link once you've been denied benefits, that's a red flag, because you should get that so that you can apply for those benefits. Next slide. So these are just some of the common issues that we have encountered when we've had clients to contact us about their unemployment benefits. We've had situations where an individual has applied for regular unemployment benefits, but they haven't gotten a decision. For example, they've applied back in March, and here it is now in July, and still no decision as to whether they've been approved or denied. We've had situations where the benefits were approved, but no benefits were received, or that the benefits were approved, the card that the benefits go on was mailed to the individual, but nothing was on the card. And in that instance, what I found, at least with one of my clients, is that the benefits were being placed on the card, but there was an issue with the supplier of the card. So what we had to do was reach out to the supplier of the card. They were able to fix the issue, and all of the client's benefits were placed on the card. We've had instances where there's been a denial of unemployment benefits, but then they didn't provide a link to apply for the pandemic unemployment assistance. As I stated earlier, that's a red flag. Definitely need to be reaching out to the customer service line, trying to find out, whether you can get the link at this point so that you can apply for the pandemic unemployment assistance. And those same issues that I stated as it relates to applying for regular state benefits, we've also seen those issues in applying for pandemic unemployment assistance. We've also seen those instances where benefits were terminated, but the individual didn't get a written notice. They may have gotten a call from a representative from the Department of Labor, basically telling them that their benefits have been terminated, but never sent them a letter. So what I would say to anyone who is having any of these issues, that you should contact Georgia Legal Services. Next slide. Or contact Atlanta Legal Aid for assistance with any of the issues that you may have. And I have placed on the slide the contact information for Georgia Legal Services, as well as the contact information for Atlanta Legal Aid and the counties that both entities serve. Thank you.
Thanks, Celinda. Appreciate that overview. Helpful information around unemployment benefits. So at this time, maybe I'll bring back Emily to see if we have time for additional questions. I know that the team was working hard behind the scenes answering those questions that came up in the chat box. But I think we do have time for a few more questions if there are any.
We do have time. A reminder to everybody, you can submit those questions in the chat. We will stick around a little longer, but I do want to say, first of all, thank you to everybody on this call. Thank you for the great and necessary work that you do to serve Georgians. And especially thank you to the Georgia Legal Services team, Rick, Kaleem, Cynthia, Fran, Celinda, and Jackie and Vicky, who helped to get this set up for them as well. We really appreciate you all taking the time and sharing your expertise with us today. We do have a question about bilingual staff that's come up a few times. Rick, I'll let you give the answer on that.
The answer is yes. We do have bilingual staff, both legal professionals, our intake specialists, and several lawyers. So well